We need a good old product. Sean, we need good old product.
Yes, sir.
On the record, in the matter of the people of the state of Michigan versus Laura Lazo Viltrace, 24-03439, Council Mechanics.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
Karen Robinson, Assistant Public Defender for Ms. Lazo Trust.
And we have an interpreter. Please state your name for the record.
My name is Frank Vappel.
Raise your right hand. Do you solemnly swear or affirm that you interpret in the matter before the court completely and accurately and not divulge confidential communication to help you God? You're able to date set for preliminary examination. This was for assault with a dangerous weapon. And then there was a misdemeanor domestic violence. How are we proceeding?
Your Honor, at this time, the necessary witness, Rafael Reyes Gonzalez, has not appeared. Our office did send a subpoena to him. We did see him last week at the PCC, where he provided an updated email to send those subpoenas to. Our office did that, but we've also received some communications from Mr. Gonzalez indicating he did not want to proceed or go forward with this case. So at this time, people are unable to proceed.
You would be making a motion to dismiss.
Thank you. Also, for the record, the court did receive a letter from the alleged victim back on December 3rd. And ultimately, he's recanting an assault had occurred. So the truth is that Laura never assaulted me with a knife, and I want to be clear, she was in the kitchen preparing the food and had a knife in her hand. But the knife was using it to make the food. At no time did she try to hurt me with the knife. I really don't remember what I told the police because of the state I was in. The truth is Laura never tried to hurt me. Motion to dismiss is granted without prejudice. It's a three-page letter. You just read that portion. I don't know if you got the same letter.
That's pretty similar. It sounds like
Did
we
you get a
got.
copy of that letter?
I did not.
We'll get you a copy of
Thank you.
that.
I just picked up that.
Oh, was that the one that you sent me? Then yes, I
did
do have
forward
it.
an email.
Okay, sounds good. Okay. We'll get you a copy of the dismissal, okay? You have any questions for the court? You just no matters for the record.
Nothing from the people.
No, Your Honor.
You're all set. Ah. Can you hear us, Mr. Carter?
Yes, ma'am.
If I,
Yeah.
oh,
the record in the matter of the people of the state of Michigan versus Anthony Goodall, 24-03541, council appearance.
Good afternoon, Your Honor. Good morning, Your Honor. Casey Markarian, and hearing on behalf.
Karen Robinson, Assistant Public Defender, for Mr. Goodall.
Okay, Mr. Goodall has a preliminary examination scheduled today for a motor vehicle UVA, police officer fee, and a police officer assault. And my understanding is that there's an unconditional waiver today.
That's correct, Judge.
Turn on.
Your Honor, there's an offer to work out a global resolution at circuit court. I believe that's the purpose of the waiver here today. For Your Honor's reference, Mr. Goodall has a pending larceny and building matter in the 55th District Court set for preliminary exam next week with Judge Hillman. He also has this case here and a few misdemeanor cases in your court as well, Your Honor. The offer was to plead guilty to the larceny in a building, the motor vehicle unlawful driving away charge with HYTA status, and then we would dismiss the balance of his fines.
That is accurate, and he does wish to accept that open circuit court.
I should say there's also a retail fraud second in review that was included as a part of the deal too.
Thank you. Mr. Goodall, you understand that you have the right to have a preliminary examination in this matter here in the district court. You understand that you have the right to require the prosecution put forth evidence that would establish sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You would like to unconditionally waive your exam today.
Yeah, I redid it already. I think it's in your index. I said I redid it yesterday. I think it's in your index.
Oh. Confined over must be the 8th because confined over would be the 1st. Confined over date's gonna be January 8th. That's the date that the district court's gonna get the file to the circuit court, okay? You do not need to appear in the circuit court on that date. Your next court date in circuit court will be a pre-trial. Your attorney will be made aware of that date, okay? You have any questions for the court? It's like bond was set at 4,000, 10% with a GPS tether and victim notification.
We would be asking to address bond today, Judge.
You can address them.
Yes, Your Honor, we would be asking the court to convert Mr. Goodall's bond from a 10% bond to a personal recognizance bond at this time. He has been in custody since his arrest. We have worked out an offer between the prosecution and I that would likely involve HYTA and probation status. So I don't believe that he would be such a danger to the community that he wouldn't be able to reside in the community. Further, I've spoken to Mr. Goodall about the importance of coming to court. He lets me know that he does have a stable address and phone number at this point, and will assure the court that he will appear here on time for all scheduled appearances.
Yes, the prosecution gonna respond.
Your Honor, I will ultimately leave it to your discretion. I think the reason that a GPS tether might have been put in this case, I don't want to get into the mindset of the magistrate. magistrate, but there was a victim involved. This incident involved allegations of defendant going over to the victim's apartment to meet up with them and then fleeing with the vehicle while the victim went to the restroom. So that might be the reason why a GPS tether was
I
ordered.
looked at the affidavit of probable cause. Wasn't a victim notification if possible, I guess. Is okay, it doesn't sound like they have any ongoing communication. Let's see.
I did speak with the victim on this matter, Your Honor. It sounded like it was a one-time incident. Doesn't sound like there was any ongoing communication.
He's not on probation or parole,
Not that I'm aware of, no.
just other criminal matters can be.
Correct.
What's his bond in the other matters?
He also has a 10% bond up in the 55th cases. But those were set after this case was set for a 10% bond, I believe, so that he could keep earning credit on those.
He's not placed on probation before the 56-day district court.
No, Your Honor, he states that he's never been on probation.
What's his address?
235 Center Drive, Lansing, Michigan, 48917,
Your phone number.
517-846-1712.
Bond is admitted to 4,000 personal recognizance with GPS tether and victim notification if possible.
Thank you, Your Honor.
You need to appear for all of your court dates. Your bond conditions are still include that you're not to have contact directly or indirectly with the alleged victim. You're not to leave the state without prior approval of the court. Not to use drugs or alcohol unless you have a valid prescription. You need to report to pretrial services within 48 hours of your release. Do you understand that? Do you have any questions for the court? You want to ask for the record?
Nothing from the people.
No, Your Honor, thank you.
You're all set. The record is a matter of the people of the state of Michigan versus Jalen Carter, 24-01031. Appearance, please.
Morning, Your Honor. Case appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Jalen Carter, who is appearing separately from Union County Jail.
Okay, Mr. Carter, we have a pre-sentence report today for your sentencing. Counsel, did you get a copy of that?
I do, Your Honor, and at this time, the only correction I would make is to the earned credit. At this point, he has, my estimation, he has 82 days credit.
Make allocation.
Thank you, Your Honor. Today we are here for sentencing. This is a retail fraud second. We are asking the court to put Mr. Carter on a term of probation under the Home Dutiful Trainee Act so that he, if so he can complete the probation, he can keep this off his record. He has, it's my, I'm sorry, I believe he doesn't have a record. It's my understanding he doesn't. So this would be very apropos to make sure that he keeps a clean record. He is currently working on his GED. He doesn't have that. So I believe a term of probation would be appropriate, give him under some supervision in the court so that he can get these things accomplished and hopefully not have to return to the court. Obviously, from the pre-sentencing report, you've seen that he regrets his decisions. We do have restitution in the amount of a little over $1,000 that he's agreed to pay. So, Your Honor, we just ask the court to follow the recommendation. Thank you.
Okay, I have a pre-sentence report. It indicates here. Admitted to stealing at the date and time. We knew we did that on at the time of the plea. The recommendation is that they believe that he would benefit from completing moral recognition, a training program to help him develop some goals and articulate his values. That the defendant did mention that he was enrolled in a high school diploma GED program while incarcerated. And if he does not complete it by sentencing, it would benefit from him obtaining his diploma high school while on probation. And the recommendation is to grant status under HYTA. Did your client want to make a statement?
Mr. Carter, did you want to say anything before sentence?
Sentence of the court is 365 days. For 82. Spend the balance upon successful completion of 8 months probation. While on probation, you are required to participate in the moral recognition therapy program, as well as continuing your GED high school diploma. And you need to obtain and maintain employment. Do you understand that?
Yes, Your Honor.
You're not to be at the Target on Edgewood Boulevard. You understand that?
Yes, Your Honor.
You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use or possess alcohol, marijuana, or controlled substance unless you have a valid prescription. You will be required to submit to random preliminary breath testing and urinalysis testing. You're responsible for the cost of that, and you're not to be at any bars or nightclubs. Do you have any questions so far?
No, Your Honor.
Also, while on probation, you will be making monthly payments. You have a large sum of restitution that's owed to Target at 500 East Edgewood. You owe $1,089.92. The $75 crime victim rights fee that must be assessed, plus a $50 state minimum cost that will be assessed. There's a $30 per month oversight fee that you're responsible for while on probation. You're gonna do 8 months of probation, so it's $240 in probation oversight fees. I'll waive discretionary fines and costs, and you'll make monthly payments on the total amount. Total fines and costs at this time is $1,454.92. It's about $182 a month that you're gonna have to make a payment of. You understand that?
Yes, Your Honor.
I'm also gonna order that you perform 20 hours of community service within the next 60 days. And 10 of those hours must be served at the LMTS Outreach Center in Lansing. You understand that?
Yes, Your Honor.
Do you have any questions about your probation requirements or your fines and costs?
No,
Will you sign this for me? Okay, lastly, there's an advice of rights as to probation. Oh, I didn't say it, but I will grant H1TA status. There's an advice of rights as to probation. It says you've been placed on a term of probation before the 54A District Court, and your terms are specifically tailored to address your assessed risks and needs. You have the right to request early discharge from probation once you completed half the original term ordered by the court, so long as you completed all of the required programming that the court ordered, and you have not made or had any violations within 90 days prior to your request. In order to make the request for early discharge from probation, you will use the court's MC 512 form. That's located on the court website, or you can get a copy of it from your probation officer. You'll complete that form, you serve a copy of it on probation, and you must serve a copy of that form on the prosecution's office. The prosecutor's office has 14 days from receipt of your notice to file any written objections to early discharge. If the court sets the matter for hearing, you have the right to hire an attorney to represent you for that hearing. You do not have the right to court-appointed counsel for any hearing for early discharge. Do you have any questions about that right?
no, Your Honor.
Anything else holding him other than this?
No.
Okay, you need to check in with our probation department no later than Tuesday of next week by 9:30, okay?
All right.
What's your address?
I don't have an address right now because I was living with my cousin before I got locked up, and then she moved, so I don't know right now until I get out.
You need to, I just realized Tuesday is Christmas Eve. So you need to check in by Monday, okay?
Okay.
Your Honor, I have instructed Mr. Carter about where to go when he gets released to check in probation.
Very good. What's your phone number, sir?
517-715-7432.
Any additional matters for the record?
Nothing from the people.
Nothing for defense.
We're all set. Thank you, sir.